Well, we know by now that Sarah Boone's defense team filed a motion to suppress her entire interrogation. That entire 2 hours of interrogation, the defense is asking to be thrown out, not admissible. Why? Because there was a Miranda violation. That's essentially what their motion comes down to. Now, we did a video, our last video actually was explaining and breaking down that defense's motion to suppress that 2-hour interrogation. So if you haven't seen that, definitely go check that out, because today's video, we're going to be jumping into the state's response. That's right. They filed a response today, September 27th, filed at 1:30 p.m. They filed a response, and it's a doozy. It's a good one, and it's a lot of fun because they bring out a lot of the points that I made in my last video, which I was talking about the problems with Sarah Boone's motion to suppress all this evidence. So let's jump into the response right now. I'll pull it up for you. It's not too long. It's a little bit longer than the motion, but we'll go through it quickly like we always do, and we'll explain and give our analysis. And this is going to be fun anyway. So here we go. All right. So this is it. State's motion to strike defendant's motion to suppress statements at Orange County Sheriff's Office, and state's response to defendant's motion to suppress statements at Orange County Sheriff's Office. Now, why do they say it like that? Well, the first argument that they're going to make here is that this motion should not even be heard. It should be stricken. You know, sometimes you have a motion and we have to file a response, and then the judge has to decide, okay, who's right? But sometimes a motion is so deficient that it shouldn't even be heard by the court. So that's the first part of this response, is that we don't even need to really respond, and we shouldn't really go to a hearing on this motion because the defense here failed. Their motion is legally insufficient. So here we go. Number one, the defendant's motion is legally insufficient. Now, there's different types of insufficiency, right? One is if a motion is factually insufficient. I can't just tell the court something without laying out the appropriate facts that have to do with that motion. So you can say something's factually insufficient, or you can say, well, they did say the facts. There's enough facts in that motion to perhaps bring up an issue, but there's no legal basis for what they're asking for. So this is what they're essentially their first argument, which is really what my first argument was on as soon as I saw that defense's motion, was that they quoted no authority. And you're going to be seeing this come up a lot. So the defendant's motion is legally insufficient. The defendant recites all allegations of facts, but not why any particular fact or facts is an issue. The reasons for suppression, as required by Florida Rule of Criminal Procedure 3.190 H2, that is the rule of criminal procedure which deals with a motion to suppress. So, again, the reasons for suppression, as required by this rule, is a boilerplate assertion that it violated the United States Constitution and the Florida Constitution. This is no different than stating a search was performed illegally and improperly and unlawfully, meaning that's not enough just to say, oh, they did something illegally. That's not enough just to say, oh, we moved to suppress. Why? What would give us some basis? There's got to be something that you bring in front of the court as a basis for what you're asking. So again, this is no different than stating a search was performed illegally and improperly and unlawfully. That was a case called the State versus Christmas. And then again, see Ross versus State. Remember, I quoted the case Ross versus State. So this is a motion to suppress that cited 11 authoritative cases was legal sufficient. So in Ross versus State, that was actually a very interesting case. But at this point, what happened here was it was brought up to the Supreme Court in Florida, and one of the arguments was whether there was enough of a legal basis, and the Florida Supreme Court said yes. They quoted 11 authoritative cases. Obviously, that's legally sufficient. How many cases did the defendant quote? Well, let's see. The defendant has not even cited a single case that authorizes the court to grant her the relief she is requesting. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority, that's the magic words, what legal authority there might be for the court to grant the relief she requests. State versus Butterfield. The court should strike the motion as legally insufficient, which is also based on the case of, like we said, State versus Christmas, where essentially that's what happened in that case. The court said this motion should have never even be heard. It should have been stricken as legally insufficient. But they're going to continue to argue anyway, because they're not just going to rely on the fact that the motion is legal insufficient. Now they're going to also show why whatever their defense is arguing is incorrect. So here we go. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. This is also, again, a State versus Christmas, where if in that case, if they brought a specific issue in front of the court, and now if you want to change the issue all of a sudden at the hearing, you can't do that. You're limited to the issue that you wrote in your motion. So if you want the court to take something up, you got to put it in your motion first. You can't just get there and say, well, Your Honor, we're all here anyway. We're on the record. Let me bring up some other issues to discuss. Now, sometimes during trial that can happen as things are on the fly. But when you have, generally speaking, when you have a motion, the court is going to be limited to whatever you're asking for in that motion. So here we go. They're saying, look, if they come up with other claims at the hearing, then the judge, you should not entertain that. So that's another thing that they're arguing over here. Okay, in paragraph 5 and 6 of her motion, she alleges that she was detained for 14 hours. Remember that? She was detained for 14 hours. And I asked, when I was reading that, I was like, hey, what does that have to do with anything? Like, what exactly does that have to do with the Miranda rights? But they're going to argue that right now, that she was detained for 14 hours. And during this time, she provided a statement to law enforcement, right? That's correct. Those were the facts, that she was detained for 14 hours and she gave a statement to law enforcement. She does not challenge the admissibility of the statement. That's not what they argued for in that motion. They didn't say that statement therefore should not come in because she was detained for 14 hours. That's not really where their argument comes in their motion. And then you have the case of Chavez versus State, that in case they do want to make some sort of argument that if you're detained, that makes the statement involuntary. There's this case called Chavez versus State, where in that case, the person was detained for 54 hours. 54 hours, and that the court found did not automatically, the fact that you're detained for that many hours, that does not automatically make the statement involuntary. Okay, so it doesn't make it, again, like we said with Miranda, the issue with Miranda is that you cannot be forced to give any sort of statement once you're in custody and once you're in the middle of an interrogation. You can't be forced to do anything. Now, does that mean once I read the Miranda rights as a police officer, now I can make their life so miserable and do whatever and threaten them and make their life completely miserable because after all, I read the Miranda rights? No, obviously you can't do that. So the question is, okay, well, what about just detaining them for hours and hours and hours and hours and hours on end? And then they know, okay, I better start talking, and that's the only way that I'm going to get out of this situation. Well, that can be considered coercive. And if it's coercive, so then it doesn't matter whether you read the Miranda rights or not, that's considered that you did not waive it. So here, in this case, Chavez versus State, the court found that 54 hours of detention does not make the statement involuntary because, again, if you're providing food, you're providing breaks, you can say, let's take a break now, go home, get some rest, come back. That's fine. As long as you're not coercing them, then it doesn't matter how long it may take, as long as you're making their life comfortable and you're making it livable for them. So that was what happened. So therefore, they're saying, okay, 14 hours, big whoop, doesn't make a difference. All right, let's move on. Paragraph 7 and 8 of the defendant's motion allege that law enforcement asked for the defendant to turn over her phone and that she provided the means to unlock it to law enforcement, right? That was one of the things that happened. They asked Sarah Boone for her phone and she gave over her phone, and then she gave them the passcode and they were able to get into her phone. And that's how we all saw that video. So maybe they're going to make some sort of issue with that. So Bell versus State is informative on this issue if it is the defendant's position that this somehow rendered her statement the following day involuntary. So again, they're trying to grappling with what is your point? Like I made it when we in the last video that we did yesterday was, what's your point when you're saying all of these facts? Are you trying to relate some sort of law and some sort of argument to these facts? Or are you just saying a sob story? So you always have to connect what facts are connected to the legal issue here. So here, the state is just saying, we don't even know what they're arguing, but maybe they're just guessing. Maybe their position is that somehow by us taking away her phone, that makes her statement the following day involuntary. So Bell versus State is actually very informative on this issue, as we're going to see. Bell makes it clear that the police, having seized evidence from a suspect and the suspect knowing they have seized evidence from her, only goes toward the analysis as whether a future interrogation is custodial. Okay. So remember, this all comes down to whether this person was in custody. Are you in custody? If you're in custody, then that triggers Miranda. And again, that's if you're in custody and there's going to be an interrogation. So if you're in custody and there's an interrogation, that triggers Miranda. Well, what happens if I steal your phone? I won't say steal. Let's say they seize your phone. The police seize your phone. Now you want your phone. You want your phone back. So is that considered a custodial situation or not? Well, in the case of Bell, what happened in Bell is that they took the person's phone and then they brought him down to the station and they were in an interrogation room and there's a lot of other issues going on there. So it looked like this was a custodial interrogation. Now they never read the Miranda rights in that case. So in that case, because they never eventually read the Miranda rights, and the court felt from the totality of the circumstances, the fact that he took that defendant's phone initially, they seized the phone, and then they brought him down to the station and they told him about this investigation that they're doing and that he was in the interrogation room and they were asking him all these questions and they're saying that I may arrest you and threatening things like that, and still no Miranda rights were read in that case in Bell. That's when they found that this was considered a custodial relationship, and then the future statement that came in was considered involuntary. Now, in this case, remember, there were Miranda warnings that were read. So the fact that they took her phone beforehand doesn't automatically mean that any statement now that you give is not considered voluntary, because if eventually she comes down to the station and then you read the Miranda warnings or the Miranda rights, so then, okay, great, you can continue. It's not considered involuntary. So again, the question is only whether a future interrogation is custodial, not whether a future statement is involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, in this case, Sarah Boone was given her Miranda rights. They were read to her. So then you can't argue, well, what does the phone have to do with anything? This is not relevant factor for the court to consider. So continuing. Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below, which we kind of already discussed just before. Moving on. Paragraphs 9 through 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning her for an interview. She did not know that was going to occur, right? We remember that they told her that she just has to come down to get her phone, and that the detective was pregnant and she was feeling sick, and they lured her. They were being deceptive in order to get Sarah Boone to come to the station, right? So what's their argument here? Well, pursuant to Bell, this goes to one of the Ramirez factors in deciding whether Miranda warnings were required, not whether a statement is involuntary. So again, are you arguing, Sarah Boone, are you arguing that a Miranda warning wasn't given at the appropriate time? Is that what you're arguing? That did not seem to be your argument in your motion. And because in this case, the Miranda warnings were given both twice. So you can't be arguing. It doesn't make sense to argue that the Miranda warnings weren't given, because they were given. So that can't be what your argument is. Your argument is that even though the Miranda rights were read, maybe there was no waiver of the Miranda rights. That's essentially what their argument came down to. And therefore, the statement that you gave was involuntary. So again, this issue of being deceptive, it just determines whether that triggers a Miranda warning to be given. That's all that triggers. So whether we were being deceptive in this case and getting you down to the station doesn't matter, because at the end of the day, we did give you your Miranda rights. The question is whether you waive them or not. So that's a whole different question. That has nothing to do with us being deceptive getting you there. All right, so let's move on. Again, this is different from the deception that would lead to an involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. So just because the policemen are being deceptive does not automatically mean that your statements are now not considered voluntary. So if you're going to try to make that connection, that's going to be a lot harder. And again, they bring all these cases. This includes misrepresenting a co-defendant's statement, false suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against a suspect, informing a suspect that law enforcement was investigating a missing person case rather than a homicide, writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representations of physical evidence that did not exist. Meaning these are all tactics that are used in interrogation, that the detective may lure you into believing certain facts that aren't really true in order to get you to talk more. Does that mean that you're not being voluntary now? No, this is clear. In this case, these are tactics that the detectives and the police officers are allowed to engage in, and it does not make your statements involuntary. So Again, all this deception is 100% fine so long as you read the Miranda rights, as long as she understood that she had the right to remain silent, and she is now waiving those rights. Okay, so the issue is going to be the waiver, not whether Miranda rights were given at all. Okay, continuing. Luring the defendant to the sheriff's office under the guise of returning her phone to her, if that is in fact what happened. Again, they're not going to say, well, that's exactly what happened. They're just saying, even if we were to believe everything that you're arguing, that this was all one big guise of luring you into the defendant's to the sheriff's office, does not make the statement involuntary. It only goes towards whether Miranda should have been read, and it was, as we've been explaining up until now. All right, let's continue. Paragraphs 12 and 13 also only go toward the first Ramirez factor as to whether Miranda should have been read to the defendant. So the Ramirez factors are about, there's a number of factors that are given in this case called Ramirez. And that essentially, that tells us whether a reasonable person in that same position would believe that he is in custody. That is the question. So there's a number of different factors that goes into, which just triggers Miranda. That's all it does. All it does is that it triggers, and now you're in custody. So now we have to read you Miranda. So all of this really is not relevant because the Miranda rights were read to her. So let's continue. Paragraph 713 also only go towards the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued after Miranda was read to the defendant. Nor is there coercion. Although the defendant has not specifically made that claim or cited authority, again, they haven't cited any authority, and they didn't say that her statements were coerced. Martin versus State. And listen to this. What is considered coercion and what's not? Well, here we go. Allegations that law enforcement, number one, threatened the suspect with the death penalty. So does that make it that the statement now is coerced if we threatened you with the death penalty? We're going to see. What about deluded the suspect as to what he could expect for himself and from a jury if he confessed? Let's say you say, well, if you just confess, everything's going to be fine. If you just confess, you're going to feel great about yourself, and the jury's probably going to leave you alone. And, you make up all this stuff. Does that mean that you're coerced or not? And we're going to see all these cases are going to be found that no, that was not considered coercion. Continuing. If you deceive the suspect as to the amount of time he had to cooperate with law enforcement, if you say, we just only need you for an hour, and you're like, okay, great, I'll just get out of this in an hour and just say what you want. Then they keep you there for another 10 hours. Well, is that considered coercion? Not at all. Promise their favorable testimony and use of their influence during his trial if he cooperated. If you do that, that's not considered coercion either. Promise to arrange a visit for him with his girlfriend if he cooperated. These are all cases that happen. Exploited his religious beliefs by relying on a version of the Christian burial interrogation technique. That's an interrogation technique where they say to a person who's very religious, say, that person that only where they're buried, they deserve a Christian burial. I mean, don't you believe that also? And you kind of play with his religious beliefs to get him to confess. All of these things did not render the statement involuntary, though it presented the very outer limit as to what tactics law enforcement may employ when performing a custodial interrogation. So these are extreme cases, but they still fall within what's considered involuntary. So all of these statements are still considered involuntary, even though you use these tactics, but don't push it any further than that. That's essentially what this case says. So again, was Sarah Boone anything worse than what we just heard of those interrogation techniques? No. Although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law on the subject, as we continually see throughout this brief, because they don't, which is their main problem with their motion, the state infers that she believes this an issue due to what she has underlined in paragraph 15 of her motion. So remember, I showed you how she underlined and well, this again, it's not her, it's her attorneys, but underlined and bolded certain things. So they're trying to show how that the police, again, this is a suggestion by the state, that maybe the defendant is arguing that all of her statements should be suppressed because the police were minimizing her Miranda warnings, because they were saying, we must talk. We have to talk about this. And therefore, that kind of minimize her rights under Miranda. So that this is, again, an argument that the defendant is making up for the state. So here we go. There are several cases addressing the issue of minimizing the importance of Miranda warnings, and they cite all of these cases. Saying this is something I have to do is not minimizing. So even though you underlined it and bolded it, as we discussed in our last video, that doesn't mean that we're minimizing the Miranda warnings. So again, saying this is something I have to do is not minimizing according to Wright, which is analogous to Detective Counsel saying, so I'm going to read you your rights again because we have to talk about that. So in the case of Wright, the detective said, this is something I have to do. In this case, Detective Counsel said, so I'm going to read you your rights again because we have to talk about that. We just have to do it. So that, again, it's the same thing as this is something I have to do. And they were read in normal cadence, like in Chaffin. So as long as you're not stressing anything and giving them scary eyes or whatever it is, as long as you're just reading it like normal, which you can tell from the videos that she was doing, she was just reading it. So then they're not going to say that it's minimizing the Miranda warnings. There was no delay in reading them. There's also no delay. The defendant is not a juvenile, right? She's not underage, and there's no claim that she's of below average intelligence. In fact, just the opposite. She claims that she is very intelligent. She had been read her Miranda warnings just the day before and acknowledged this. It is the defendant who says it is normal protocol, right? That's something that she said, that this is normal protocol. So she understands everything, okay? Let's be honest about this. She understands everything. We're not minimizing anything just because we said we just have to do it or we have to talk about that. The case law is clear that there's nothing wrong with what we did. These statements by law enforcement did not render her waiver of her Miranda rights involuntary or her statement involuntary under a totality of circumstances analysis. In the balance of paragraph 15 of her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Counsel. Paragraph 17 through 21 outline what she believes the sheriff's office Miranda card says. Remember, they said we didn't get this card, but this is probably what it says. And somebody actually commented that they did a Google search, and that's what came up in the Google search. So maybe this is what Miranda cards say, maybe it doesn't say. But anyway, in her motion, she wrote, again, her defense attorney wrote, she believes the sheriff's office Miranda card says that specific, those specific statements, which we read in yesterday's video, and how it differs from what she was told by Detective Counsel. Interestingly, the defendants belief that this creates some sort of legal impediment to the admissibility of her 2-hour statement that day is not backed up by a single citation to any legal authority within or without the state of Florida's court system. So again, the argument here is that the Detective Counsel did not read that final question on that Miranda card. Knowing all this, do you still want to talk to us? And the defendant's argument that creates some sort of legal impediment. Well, if it does, where is your citation to legal authority? That's essentially what they're arguing here. So I'm glad they're listening to brother counsel. That's exactly what they should do. All right, continuing. Instead, what does she do? She makes a boilerplate assertion in paragraph 22 that her statement was involuntary. Just, it's involuntary, finished. So like a conclusory statement, it's a boilerplate assertion, and her waiver Miranda rights were involuntary. Well, fortunately for the state of Florida, there is case law on this issue. There is no specific way that Miranda warnings must be given. So they're saying the case law. We're going to actually bring case law, which is something that the defendant did not do in this motion, to show you that everything that we did was completely fine and that she did not, her waiver of Miranda rights was not involuntary. So here we go. There's no specific way that Miranda warnings must be given. And with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. So this is part of the issue that came up in that hearing before this was, who cares what's written on the Orange County Sheriff's Office card? Miranda is pursuant to case law. So if you have an issue, bring it up and cite the relevant cases that have to do with it. What's written on the card has nothing to do with this. So, and they cite all these cases that Miranda warnings have to be given, I guess, nothing to do with the Orange County Sheriff's Office, how they interpret it or what language they use. All these cases right here. And here we go. While the 4 required warnings have become embedded in police practice, there are 4 required warnings, the specific words used vary. So you don't have to use a specific language, a specific words. There's no magic words here. As long as you convey the 4 warnings, then everything's fine. And the Supreme Court use vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. There's no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. So there's no exact language how you have to convey the Miranda warnings. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. Is this reasonable? Does a reasonable person understand the warnings that you're giving them and the rights that are covered under Miranda. The crucial test for determining whether police gave a proper warning is whether the words and the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. Detective Counsel specifically instructed the defendant on each of her four Miranda rights. Number one, the right to remain silent. Number two, that anything said can be used against her. Number three, she had a right to an attorney before and during questioning. And number four, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant said she did. So that's it. The four rights were communicated. There's no magic language, so everything is completely fine. They satisfied their requirements under Miranda. State versus Onus is directly on point. There, the defendant was read the four Miranda rights, asked if he understood them, and asked if anyone had threatened him or promised him anything. There is no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. So in State versus Owens, we had a similar issue, and over there was no question about whether the defendant wanted to continue talking after he was given the Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which were described as exemplary. So whatever was done in this case was described as exemplary, and there was no question there asked. So you don't have to ask that question very clearly. The Miranda decision never contemplated that waiver of counsels could be accomplished only by the use of the words, "I am willing to answer questions," without the services of a lawyer. So you don't have to do that. There is no magic in these words. Any clear and unambiguous conduct by a person who has been advised of his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. Again, this is straight out of a case. As long as you act, the conduct of a person who has been advised of his rights show that he is willing to answer questions, which is what's the conduct? Answering questions. So then that is surely sufficient. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, which it probably is, it should deny it on its merits. If the court believes there was a Miranda violation, then the defendant's statements are still available for use during a cross-examination. Okay, so they're saying that even if you believe that there was a Miranda violation, technically they can still come in to be used as cross-examination. Okay, that's a different issue, which we don't have to get into right now, because there's no way that he's going to suppress this. Only if the court finds the statements to be involuntary will the state be prohibited from using them in cross-examination. Okay, that's a different issue about whether the statements are involuntary or not, and then the question is going to be whether they're available for cross-examination. This is just really to cover all bases, but the court is never going to get here because, like I said in the beginning, especially in yesterday's video, the court is not going to suppress this 2-hour interrogation. So a great response by the state. The only thing that I would suggest that the state could have done a little bit better is to show specifically where it says in the case law that you implicitly waive your Miranda rights if you don't invoke your right. There's a clear case law in Florida that says this. I looked this up yesterday, that you have to invoke your right to remain silent. And if you don't, then you have implicitly waived it. And that's very clear what happened in this case. She did not invoke ever her right to remain silent or her right for a lawyer. And it's clear that if you don't invoke that right, then you have waived it by implication. So that is, but other than that, a great response, a fun response. We all knew this was coming. If you were watching my video yesterday, you knew this was all coming. So now we get to actually see it play out. And we're going to have a hearing to look forward to see how the judge actually is going to just strike this motion. And I don't even know if he's going to hear it. He may just say it's legal insufficient. We're not going to even hear it, but probably just to make the record clear, he'll say, okay, let's just hear it so that, take care of all the appealable issues and say, okay, well, we're still going to not suppress the interrogation because, like we said, all the case law is clear that there's nothing that was involuntary about this statement, and the Miranda rights were very clearly given. The only issue really that they can be bringing up is when Miranda should have been read to her, and it was clear that Miranda was read right away. So there's really no argument there. This is just a waste of emotion, really. So that is going to be it for now. We will be continuing to follow this. The Sarah Boone, very interesting. We got a trial coming up very soon. There's been another interesting motion, which I hope to get to next week, that was filed by Sarah Boone, wanting to have civilian clothing and as well as having her hair done and some makeup done. So we'll jump into the case law on that and the motion probably in the next video. So until that time, please, if you haven't yet, please subscribe, like, and we will see you next time.